Hello and welcome to another episode of the Mourant Vlog Series. My name is Alexander Hawkins and I'm a Senior Associate in the International Trust and Private Client team. I'm going to talk today about letters of wishes, specifically how a trustee should treat a letter of wishes made by the settlor of the trust. It seems like a simple enough proposition, do what the settlor wants, if only that were the case. In fact, this is an issue that we are seeing more often, and it usually arises when the trust fund has a lot of value and the beneficiaries do not see eye to eye. Consider this. A settlor establishes a trust with a nominal sum of money in it. They then prepare a letter of wishes saying the trust fund is to be treated as follows: 1/4 for his son and 3/4 for his daughter, on the basis that the daughter is involved in running the family business. The trust fund grows substantially over a number of years, and the settlor now requests that the division be formalised through the creation of sub-funds. How does the trustee respond to this? At its simplest, it is just a decision like any other. The trustee must decide whether to follow the letter of wishes or not to. However, in making the decision, the trustee must act responsibly and in good faith and take only relevant matters into account. I'm not going to address the first point in this episode, except to say that whilst the phrase acting in good faith is general, sometimes unhelpfully so, what is meant by it is that the trustee must give genuine consideration to the exercise of its powers. It is the second point, taking only relevant matters into account, which I want to briefly discuss today. It is important that a trustee knows what it ought to consider before making a decision about a settlor's request. The trustee needs to follow a proper process, as this process and the trustee's ultimate decision may come under scrutiny if a beneficiary is aggrieved or if the decision is a momentous one, which it would be if the trust fund is of significant value. Then the trustee may need to explain the process that it follows to a court. A trustee is under a duty to take relevant matters into account and ignore irrelevant matters. The duty requires them to inform themselves before taking a decision of matters material to it, including when necessary advice from experts such as lawyers or accountants. How does this work practically though? In a conventional family trust, the assets of the trust belong to the settlor. Except to the extent that the settlor has reserved powers, the trustee is the means that the settlor has chosen to benefit the beneficiaries out of their property. It follows then that so far as the trustee is given powers to distribute assets from the trustee should make choices that the settlor could have made itself. A trustee must therefore give great weight to the settlor's wishes, either expressed from time to time or recorded, usually in documentary form. In fact, the Supreme Court has held that the settlor's wishes are always a material consideration in the exercise of fiduciary discretions. And there are a lot of people, and a few well-regarded publications, that take the view that a trustee is bound to follow the wishes of the settlor. However, it is not as simple as picking up a letter of wishes and blindly obliging it, even if those wishes are the wishes of the settlor. To make a decision properly by reference to proper considerations, a trustee should identify and list out what it ought to take into consideration before following a letter of wishes, and whether it needs legal and tax advice on any of those matters. Some common considerations include whether the settlor is indeed the true economic settlor of the trust. In my fact scenario before, I said that the settlor settled a nominal sum, but that the trust fund now has significant value. Where did that value come from? Did it grow organically in the trust, or was it transferred or appointed in from somewhere else? And if so, is it correct to say that the settlor remains the economic settlor? Whether the letter of wishes remains relevant. In this case, the division was proposed on the basis that the daughter was involved in the running of the family business. Is she still involved? Or has she stepped out in favour of a team of professionals? What are the tax consequences, if any, of segregating the trust fund? Do we need tax advice, for example? What are the views of the interested parties, such as the beneficiaries? The trustee should request the views of the beneficiaries and take these into consideration. Only when the trustee has identified what its relevant considerations are, gathered all the evidence that speaks to these considerations, and taken appropriate advice, should it make its decision. If the decision is a momentous one, then an application to court might be worth considering. I appreciate that this is a loaded topic and there are a number of points that I've left out. If anyone would like to discuss this with me, or if you are a trustee and are faced with a fact scenario similar to this, then do get in touch.